So it's literally fucking called the Anti-Pinkerton Act of 1893. Yeah.
This business is we can't work with
It
them.
was passed by the U.S. Congress in 1893 to limit the federal government's ability to hire private investigators and mercenaries.
Wow.
The Anti-Pinkerton Act is contained in 5 U.S.C. 3108 and purports to specifically restrict the federal government of the United States from hiring employees of Pinkerton or similar organizations such as Modern Blackwater.
Wow.
Welcome back, Gossip Without Prejudice, guys. Today we're pivoting a little bit. We've done a lot of Seattle stuff. We talked about Seattle last week. Hint, today we are actually recording this the same day as the Seattle episode, so nothing would have been improved since last time because I am actually in Toronto on a work engagement. More on that later. So we're recording a two-fer so that we can release this next week. Thank you so much for being in the studio with me for like an extra hour and a half, Sam.
Absolutely.
We're zooming out a little bit about labor relations. So have you ever heard of Milton Friedman?
I have, yeah, the economist, right?
Yeah, economist who famously, he did a lot of shit, but famously he argued that a corporation should only be concerned with profits. Inherent to that argument was the assumption, from reading a lot of Milton myself, my initial education and training was in economics, not in law. Having read a lot of his work and other, economists from around the country early in the 20th century, central to that discussion was a uniform competition between equal firms. As you can imagine, that theoretical reality is not a practical one.
Yeah.
And so I wanted to talk a little bit about how labor relations have evolved from the robber baron era and the general state of jurisprudence through today, 2025, especially with the scourge of widening income inequality.
Yeah.
It seemed a topical discussion considering that business interests are front and center at the federal level right now.
Yeah.
Lochner v. New York is where a lot of the foundational jurisprudence started. It's a very famous Supreme Court case. I'm going to walk you through it today. What are your thoughts on the state of labor relations just before we jump into things?
I mean, like you said, income inequality is becomes a more pressing issue every single day.
Yeah.
I mean, it's impossible to buy a house anywhere.
Yep.
Well, especially where we live,
Yep.
but for most people, unless you're a part of this upper echelon of people. I mean, and we even have there's I saw something about there's millions of millionaires in the U.S. now, and even those people aren't necessarily we used to. I feel like you think of millionaire as oh, you're set for life.
Yeah.
You made $1 million, you're done.
Yeah,
you're done working, and it's I don't know, different. It's more expensive to live than ever.
And I think I might have told you this statistic that 20 years ago, the average home buyer was 36.
Yeah.
And now it's 56, which means
Which
it's
is
just
so sad.
It's just the same. Arguably, it's just the same people that keep buying all the homes. It's the relationship is linear. It's gonna go right off the chart.
Well, and and you compound that with private equity buying up land like crazy.
The decimation of Red Lobster, and among other. Actually, that's a story.
Decimation of Red Lobster.
I may want to do some private equity horror stories. That is not what this podcast is set up to do. It's not an economics podcast, but I cannot help. I really want to explain the difference.
I just thought the downfall of Red Lobster was just too many free shrimp.
Yeah, it was. Okay, this is also not what this episode is about, but it was free shrimp. The shrimp company was bought into the board of Red Lobster to supply shrimp from the shrimp company while they owned equity in the company and then had bought into it, leveraging all the assets of the company and then leasing it back to the. So basically. A whole thing to get into.
Yeah, that sounds fascinating.
It was not simple incompetence. There was some shit going on in the background. Now, Red Lobster still exists. But anyways, we're going back to Lochner v. New York. That's a whole other episode.
Yeah.
I really want to do an episode on what VC, venture capitalist versus private equity is. They deal with different cycles in the company, in the business cycle. Is VC gets you off the ground. PE, lifts, gives you wings.
Yeah, I do have to share a story about venture capitalists
go
for a second. I used to work at a dental brokerage, and so I would interact with a lot of VCs, a lot of private equity, and there was a brand new venture capital firm that we were dealing with. Yeah. And they had just formed. It was someone from another one, and we were that's it. I forget what the name was, but we were oh, that's an interesting name. How'd you get that name? And they were like, well, when we were forming, we were at a vineyard and there was a bottle of wine that we got. And they named it after a bottle of wine that they all were sharing at this vineyard. And I was like, that is a perfect encapsulation of why people hate venture capital.
Number one self-dick writer on earth. Oh, God.
I know. I thought it was so funny. Like, man, we talked shit about it for like weeks.
That robber baron shit ties in well to what we're doing today.
Yeah.
We're talking about robber barons.
Mm-hmm.
So let me start from the top here to dive us in. Also, guys, before we get started, obligatory CTA.
Yeah.
Go like all the buttons, follow our social channels, support the podcast. Go to gossipwithoutprejudice.com. Pledge as little as $5, keeps the lights on, all that good shit. Leave a review. Leave this in. Leave a review. You fucking people, we're getting fucking half our audience is on Apple Podcasts, and none of you guys are leaving reviews. I fucking see that shit.
And you don't even need we don't need a paragraph.
Yeah.
It could be
just the stars.
Me like podcast.
Yeah. Fucking
5 stars.
Put the stars in the bag.
Yeah.
Put the stars. Okay, that's too much airtime for the CTA for the reviews, but we would appreciate we would appreciate your support, guys. Yeah. Yes, please tell us what you think. Send emails to gossipwithoutprejudice@gmail.com. We read our inbox. You can call us mean names if you pay us. You can be nice to us if you don't, but we're always looking to get feedback on how to improve. We're very much still iterating. We've got a lot of fancy equipment, but we've actually never run a podcast before, so it's been a lot of fun. Okay, to the actual story. Lochner v. New York is widely considered a landmark Supreme Court history milestone, one which kicked off an era of aggressive adherence to business interests, protections, and wealth accumulation through the Gilded Age of the robber baron. This case kicked off the so-called Lochner or Lochnerian Era, which lasted about 30 years until the political atmosphere of the Great Depression prompted the court to reverse its stance on labor protections, which we will also go over the case called West Coast Hotel versus Parrish, which ended the Lochnerian Era. We'll also go through that today. A detour that SCOTUS has struck from the record because the jurisprudence of West Coast Hotel v. Parrish generally stands to this day. So it's like persisted through the better part of a century. But the truth of the modern labor law landscape is not as black and white as it may first appear. So the inherent ruling that you should pay attention to is that under the 14th Amendment, you have due process rights. The question before Lochner was, do those 14th Amendment protections attach to corporations? Are corporations people? Actually, technically, for constitutional reasons, generally yes, though their powers are limited. But that was most apparent here in Lochner. So let me zoom out. So this is like 1903 or whatever, and social Darwinists and eugenics were like popping off. They were all the rage at the time. John D. Rockefeller himself said that, actually in Sunday school, he said this, quote, "The growth of a large business is merely the survival of the fittest." Oh, God. And a ton of I don't want to call them economists. They're more like social commentators cloaked in economics. And, Herbert Spencer in his book Social Statics argued against any provision that would allow, quote, unfit laborers to move up in the world or workplace. Now, this is not what we're going to cover in this story, but you should also know that the Nazi movement of eugenics got its roots in the UK and the US. We really exported, we didn't export Nazism per se, but we exported the pseudo-scientific measuring skulls to see how big your brain is, drawing partitions about how an undesirable's hippocampus was 20% smaller than the superior, all that shit you saw in the early century that culminated in the Holocaust. That actually came from us. And the elements of that cloak this case, and I think that context is important. Luckily, it doesn't actually come up in the jurisprudence, but you should know that when digesting this information. And this was around the time when, Milton Friedman's famous words is like, corporations care nothing but profit. Labor loses out big at first. So the background for Lochner begins in New York State. Throughout the United States in the late 1800s and early 1900s, labor rights movements really gained traction amongst the poor and working classes who struggled under horrendous working conditions. Remember the jungle? Where this was where a guy went into meat packing plants and saw that they were stuffing raw and rotting meat into sausages and then selling it with no accountability. Disgusting working conditions, disgusting consumer product marketplaces. There were no regulations at the time. The Jungle made that very, very, very apparent.
Yeah.
Very cool book, especially in its point in history. And virtually no protections from the state. To combat this, many states began passing laws to address these grievances, including New York's Bakeshop Act of 1895. Now, you should also know that you criminals who remove tags from your mattress, that law doesn't apply to you, where it says illegal to remove this tag. That doesn't apply to the consumer. That applies to the mattress manufacturer. Because during this era, and it's changed a little bit since then, but way back during this era, they would just put anything in mattresses. Right.
Whoa.
And so no one would know what was in it. Like, was it asbestos and lead and gasoline and rotting hay? Like, answer, yes, maybe. And so I just wanted to do a quick call out. The marks of regulation that protects you are all around us. And the jokes about the tag about illegal to remove, that's to defend you, because it tells you like 50% cotton, 20% polyester, cotton filling, wool, synthetics, whatever. It tells you what's in there, and they're held to it, and manufacturers can't take it off to hide that from you. So anyways, Bakeshop Act of 1895. The inspiration for this act was notoriously horrible working conditions bakers faced in this era. During this time, bakeries, specifically in New York, were mostly housed in the basement level of tenement housing. Because the tenement housings for like migrant workers and poor people, they had to feed the masses on their way out the door to their 18-hour shift at crushing their legs in the hydraulic presses. So they'd put bakeries in every single tenement building so they could just grab a loaf, on their way out the door. Yeah, or whatever manufacturing they were doing. Because it was affordable to rent, and the flooring was sturdy enough to support the large brick ovens. So it was cheap, it was accessible, and then they'd spend their evenings presumably drinking at the bar around the corner.
Yeah, exactly.
Yeah, exactly. And then come home, beat their wife. Tenement buildings often had little to no plumbing, few windows, poor ventilation, because they weren't built as industrial spaces, but we were using them that way anyways. And were definitely not designed for commercial purposes, not good for bakers. Like, not bakery owners. It's cheap for them. But the people who actually had to man these ovens with combustible materials and sacks of flour, flour is explosive when aerosolized in a confined space, by the way. So if fires, we had no electric. This wasn't all electric infrastructure. This was all open flames.
Wow.
So tons of fires, explosions, burn injuries, not just like burning themselves, like touching a hot stove or something, but like flour would get in the air and then a spark, and then everyone would die or catch on fire, or the building would be destroyed, or the tenements, something. It was just horrific working conditions. The basements could be damp, smoky, dusty, extremely hot, or cold, depending on the season, because there was no insulation. And the ceilings were often so low that bakers had to stoop the entire time they worked, because they were in storage basements. Remember, they weren't designed as industrial spaces. Really not good for bakers, the employees that worked at these places, there also goes without saying, completely unsanitary. Which, with such unsanitary working conditions, people became concerned that the health hazards of products that came out of such places were not worth the squeeze. So in 1895, a typical baker averaged around 74 working hours a week in New York, with many working over 100 hours or more.
Jeez.
Yeah, so remember, this is manual work. This is not like an investment banker at Goldman Sachs working 120 hours. At least they get to sit.
Yeah.
I mean, it sucks, but they're well paid and they get to sit. These guys were dirt paid, never got to sit down, also could kill themselves. Bakeries, as they stood, were posing a massive public health risk, both to those who worked in them and those who consumed their products. Because remember, they're feeding the workforce of New York, which was all manufacturing and labor-based. Enter the Bakeshop Act. New York's Bakeshop Act was modeled after the United Kingdom's Bakeshop Act of 1863 because, hint, hint, the Crown had the exact same fucking problem of all the children in the mines were getting poisoned by all this explosive, disgusting bread these places were pumping out. So the UK government actually recognized the exact same problem in 1863. It just took us like 20 fucking years to do anything about it. New York's version established, go America. New York's version established a sanitation standard, including the prohibition of domestic animals and bakers sleeping in bake rooms.
That makes sense.
So no pig shit in the bakery,
Uh-huh.
please. Yeah, yeah, pretty much. But like, it was all hands off.
Yeah.
All no holds barred. So they would use
Yeah.
these spaces for whatever. And it aimed to reform working conditions for these laborers. One of these reforms was limiting a baker's time spent in these unhealthy workplaces, 10 hours per day or 60 hours per week.
Wow.
So it's like, I think it's whichever one comes first. It's not actually clear from the language, but what's important to know is that like it capped it at 60 hours a week. This was largely considered a win for workers. The labor activists stumped for limiting working hours, arguing that it promotes, not stumped as in like we're stopped, stumped as in argued. For limiting working hours, arguing that it promotes prosperity, safety, and health for the entire city, and making these limitations law protected laborers who were in no position to bargain themselves because these were low-skilled jobs, and though they were dangerous, they were not, quote-unquote, hard to do, or like it wasn't difficult to find someone else to take your place, so that they could just treat their bakers however they wanted. Of course, not all parties were happy. Who do you think wasn't happy about this?
The bakers?
No shit, they weren't. The business owners were not happy.
The business owners.
Yeah.
Oh, okay, my bad.
The
bakers I didn't know
like,
what you were talking. Yeah.
The bakery owners. Yeah. Now, opponents of the law, like laws like the Bakehouse Act, believe that social Darwinism and laissez-faire economics would keep the labor force in check and healthy, and that any government intrusion into the marketplace was detrimental. The people who were hurt the most by this new law were the master bakers, who is the owners, who are typically the owners of small bake shops that made up the bulk of the baking industry. So
and I'm not picturing a baker when I picture this guy. I'm picturing a guy with a pipe and a transatlantic accent being like,
see these workers.
These workers getting too soft. Back in my day and in 1863.
Well, I will say the industry landscape at this time, like Walmart's and Kroger's and Costco's, the mega conglomerates were not a thing. These were mostly independently owned, small, decentralized. Even the largest might have been a chain of like 5. Right. We just didn't have the mega conglomerates we do nowadays, where consolidation has brought them all together. So I actually do agree that like this does place, in context at the time, it actually does place a substantial burden
on the owners.
Because at the same time, sure, they got these guys working in the ovens, but remember, their bread doesn't sell for a lot of money, and since bread is such a common interchangeable commodity and also essential to the functioning of the wider workforce, if your bread gets $1 too high, they'll just buy from someone else. So it was a race to the bottom. But that's actually what laws like this are supposed to. They're supposed to put a floor so that the race to the bottom stops. So I'm not saying I side with the bakery owners, but just keep the context in mind when digesting this information. I do believe that this mattered to them. Is what I'm saying. And actually, just speaking to this issue, most of these master bakers employed fewer than 5 workers and ran on a very small margin of profit.
Wow.
And enter Joseph Lochner, who ran one of these small operations in Utica, New York. So follow me so far? Yeah, perfect. So now we get to the actual case of Lochner v. New York. Now, in October of 1901, Lochner, who remember is a bakery owner, was indicted by a grand jury in Oneida County. Oneida, Oneida County. Yeah, we're going with that. Oneida County, the podcast where we don't look up how to pronounce anything. Oneida County, based on an inspector's account, he was fined $50, which guess how much that is in today's money?
That's got to be absurd. I would guess like $2,000. $1,900.
$1,900. Yeah, with adjusted for inflation, he got a $1,900 fine for allowing an employee to work more than 60 hours in a single week.
Wow.
Lochner appealed to the appellate division of the New York Supreme Court, where he lost 3-2. He then tried to appeal to the New York Court of Appeals. Oh, I forgot to specify this. At the time, the appellate division of the New York Supreme Court, the Supreme Court, it switched. So the lower court is the Supreme Court, and then the appeals court is this caused massive confusion, and I actually think they only changed the name like 10 years. I think they only fixed it like recently where it was like everyone was going to the Supreme Court, but the Supreme Court is actually the lowest court. And then the appeals court
was the higher
was the
court?
higher court. Yeah, it's very stupid.
That's
Anyways,
crazy.
But I'm going to read it to you. We'll take it from the top again. Appealed to the appellate division of the New York Supreme Court, where he lost. He then tried to appeal to the New York Court of Appeals, next one up,
Yeah.
which he again lost 4-3. And now there's only one stop on the legal train. So Lochner appealed his case to the U.S. Supreme Court, where his case is accepted, and arguments began on February 23rd, 1905. So
Gotcha.
The appeals court is actually the Supreme Court. Right?
Yeah.
And so it goes the Supreme Court, and then the appellate division of the Supreme Court, and then the appeals court, and the appeals court is actually what we would think of as the Supreme. This is all. It's so stupid. I don't know why they named it this way.
So silly.
It's all upside down.
What the hell?
So the trial court is the Supreme Court.
Yeah.
But I guess they just wanted to call themselves Supreme.
Yeah.
I don't know. Very stupid. Goes to the U.S. Supreme
crazy.
Court, which is exactly what it sounds like.
Yeah.
So Lochner's team attacked the law, the Bakeshop Act, as prohibited class legislation, because it did not apply in bakers to bakers in hotels or restaurants. It only applied to individual independent operators. They also argued that baking was not a business that needed special regulation, and therefore the limitations on working hours did not fall within the purview of the state's police power.
Oh, wow.
Who were the front lines for enforcing laws related to public health and safety. So it's you have punitive authority over me, but this doesn't fall within that punitive authority. They especially compared baking to mining and said that compared to mining, baking was generally healthy.
Hey,
Yeah,
that's,
honestly,
I
actually kind of respect that take, because mining at the time was a horrific death trap where you inhaled nothing but silica particles and sent your son to work an 18-hour shift. So I actually do believe I'd rather be a baker than a miner.
Yeah, compared to eating fiberglass, smoking is very healthy.
Yeah, exactly. At the highest, that's a good analogy. At the highest level, Lochner also argued that the Bakeshop Act violated the 14th Amendment because it deprived him of life, liberty, or property without sufficient due process. So due process was historically a promise that laws would be applied through proper judicial procedure uniformly across society, subject to certain limitations. But this changed significantly after Lochner. The new interpretation under Lochner, known as substantive due process, gave courts the authority to evaluate not just how laws were enforced, but also their actual content. Substantive due process suggested that the court could nullify any state economic or social reform laws it found to conflict with constitutionally protected rights. Now, that itself is actually not that problematic. Courts should be able to do that. How it was applied here was kind of bonkers. So, well, I see you have a question. Do you have a question?
No, I don't have a question.
Okay,
I was waiting. Yeah,
All right. The state's rebuttal was not long in its opposition. New York's AG Julius M. Mayer at the time made only 3 brief points: that it was on Lochner to prove the statute was unconstitutional, that the Bakeshop Act was created to benefit public health and therefore police powers.
Yeah.
And due to that point, it did fall under the police powers purview of enforcement, right? This public, basically, they're sort of arguing a rational basis. I've talked about this on the show. Rational basis means that if you could see a potential way this policy might benefit society, then it's good, right? And that's basically the government wins button. No matter how, and it doesn't have to be proven to benefit society. It's just is there a rational basis to believe it could?
Yeah. Is it theoretically helpful?
Yeah. Is it help and not even helpful, because helpful is subjective. So could this serve a purpose? And could this serve a governmental purpose? That's the government wins button. So that's sort of what they did here. In a 5-4 decision, SCOTUS actually sided with Lochner.
Wow.
The bakery owner, the only court to rule in his favor. Invalidating New York's Bakehouse Act, they ruled that the law was an infringement on the constitutional rights to freedom of contract, which is a constitutional right. You do have a right to associate business with anyone you wish, or a person's right to sell labor to employers, also under the 14th Amendment. Basically, contract law was held superior to police powers. And inherently in a system like that, the people with the most money will be the ones to benefit the most from it. And who have the most money? Business owners. Yeah, business owners. The court had actually recently recognized this freedom as part of the liberties protected under the Due Process Clause of the 14th Amendment in Algier v. Louisiana, and used this precedent in forming their argument. In the majority opinion, Justice Peckham wrote that there was no link between a baker's hours worked and, quote, clean and wholesome bread.
Wow. That's a crazy take.
Yeah, that's actually a tough one.
Yeah.
Now, he further argued that Holden v. Hardy, a case that limited working hours for hazardous occupations like mining, did not apply to bakers. So basically they were like,
distinction.
well, how many rats there are in my bread isn't really a function of how much sleep the baker has gotten. So can we really? I mean, this is a perfect example of like it being legally correct in theory, but pretty removed from the practical reality, which is exactly the sort of stuff. The judges aren't experts.
Yeah.
I mean, they can opine on specific shit, but they actually aren't scientists or anything like that, which is actually part of the reason why so much stuff has gone wrong with forensic science. But that's an episode for another day. Since the law's clause about limiting baker working hours did not qualify as public health measure, the police could not enforce it.
Wow.
So he's like, since there's the rat bread and number of hours worked, there's too tenuous a connection there. Therefore, if there's no public health measure compelling, doesn't fall under the government's police powers authority.
Yeah, I'm not saying I agree with him, but I understand his
rationale.
Theory. His rationale.
I understand his rationale pretty well too. I again don't agree, but
it's just not. Yeah, it's not super direct. It's not like having a miner working like 60 hours and then he breaks a joist that he shouldn't because he was like mid-REM. Yeah.
Mid-REM sleep.
Mid-REM sleep and the entire mine collapses on 55 people.
Have you seen those like Pennyworth like inns where you would just pay a penny and then in this era and you would like just be hoisted over a rope to like sort of slumber stupor standing?
Oh God.
Yeah, it's super dystopian. I think that was
crazy.
more common in like the Victorian era of England, but like the basement floor would just have ropes strung across, and then you and like 50 other guys who were just washed up from the night before and just wanted to like sort of just fold for a little bit would you just pay a penny and you'd just be folded over your rope. Your arms would go over the ropes. The rope would go like around your chest, and then you'd just be able to be supported.
Oh my God. Yeah, that is so dystopian.
It's so dystopian. Yeah, exactly. Now, I will say in Lochner, there is a sliver of hope. Justice Harlan wrote that police power does in fact extend to the protection of lives and safety, and that while liberty of contract does exist, it is subordinate to the police power of like, hey, we got to maintain order here.
Yeah, exactly.
Yeah, which I agree with. In an adjoining dissent, Justice Holmes wrote that the state's right to interfere with liberty of contracts was well established, pointing out usury and Sunday work as examples. So usury is basically like here in the state of Washington, usury means unreasonable interest on loans. So it's like anti-loan shark, sort of. It applies to more than that. But it's like I can't be like, hey, man, give me $100. And then it'll be 8,000% interest. Yeah. You can't do that. Here in Washington, it's capped around 12%, 12 to 18%.
Gotcha.
It depends on the context. But it's like, hey, we've done this before. We've prevented people from we've protected people who refuse to work on Sundays for religious reasons. There's clearly a contract exception under the police powers here, but we seem to be ignoring that. And the law should not embody a particular economic theory. Like, it's like, hey, we should uniformly apply this and not just like pick favorites. Yeah. I think that's the weakest point of his, but I understand where he's coming from. Yeah. And he said that liberty is, quote, perverted when it is held to prevent the natural outcome of a dominant opinion. He wrapped up by saying that a reasonable person could see how hours worked translated to health and safety under the police powers. Watch this space, because the dissenting argument basically becomes the prevailing theory after the Great Depression. So we're going to revisit this take. Now, business owners, they fucking love this shit. Yeah. They ate this shit up. The Lochner ruling confirmed for labor activists that the American judiciary was an enemy of the working class, and the Holmes dissent in particular became a rallying cry for the progressive movements of the 20th century. This began the 1905 Lochner era. Thoughts or questions so far?
I mean, it makes sense that, this dissent, like, you can see the fostering of the working class movement, the union movement, the workers' rights movement, heading into the 1900s, starting to form with that dissent opinion.
Two fun facts is that, one, the pink, well, actually, I'll start with the second one. The new first fact is that rednecks, the term redneck, the progressive labor movement actually started in Appalachia in what is now deeply conservative communities. They were theorized to be called rednecks because they'd have red they'd be sunburned from picketing all day.
Yeah.
Right. And yeah, so that's actually where it came from. And our general disdain for the redneck stereotype came from robber barons disparaging the picketing workers as lazy, stupid, uninformed hillbillies, et cetera. And that's pervade.
Yeah.
And also, I think sadly, those communities have also forgotten a lot, not all of, but their labor union roots have been greatly eroded because of the propaganda over the last century and a half.
Absolutely. Yeah.
And then the second one is the Pinkerton Detective Agency was used by robber barons around this area. Was a national detective agency founded by an Irish socialist, by the way. He became very capitalist later once he started the National Detective Agency of the Pinkertons. Their armed militias were used to break up, in particular, striking mine workers, a variety of stuff, to surveil union leaders, to physically break up labor movements and like kill people. They killed people.
Yeah.
And the Pinkerton Detective Agency is actually, I think, the only contractor. There is a federal statute that prevents the federal government from contracting with the Pinkerton Detective Agency.
Wow.
Specifically, literally all it says, it's like 2 sentences, is that the federal government shall not hire the Pinkerton Detective Agency because of their use, the brutal use in the labor union movements. So it's literally fucking called the Anti-Pinkerton Act of 1893. Yeah.
This business is we can't work with them.
It was passed by the U.S. Congress in 1893 to limit the federal government's ability to hire private investigators and mercenaries.
Wow.
The Anti-Pinkerton Act is contained in 5 U.S.C. 3108 and purports to specifically restrict the federal government of the United States from hiring employees of Pinkerton or similar organizations such as Modern Blackwater.
Wow. That's crazy.
Yeah. The first published court case interpreting the act in 1977 held that the intent of the act was in reference to Pinkerton's activities at the time, offering quasi-military armed forces for hire in the context of strike breaking.
Yeah.
Not least the Homestead Strike of 1892, and therefore had little application to the current organization.
Jeez.
Yeah.
That's wild.
I've always wanted to be a guy so bad that I get a federal statute saying that, like, hey, maybe you shouldn't operate a paramilitary force against the poorest people in the country.
Exactly.
Not to laugh at that, but it's just so ghoulish.
I mean, it is crazy though to have such a bad organization that they're like, let's write it in the law.
Yeah, and again, by an immigrant socialist who was an ardent socialist. The founder of the Pinkerton Detective Agency was an ardent socialist for most of his life, and then he fucking came to the Americas and founded the Pinkerton Detective Agency, and then he got social Darwinist capitalist real quick.
Whoa.
Yeah, and that's what made it so egregious that they are willing to lend their quasi-military, paramilitary services to strike breaking in particular, because that was where the money was.
Yeah.
Yeah. Anyways, the decades following the Lochner case was described, unsurprisingly, as the Lochner or Lochnerian Era, because it was one of those things where we look back and we were like, oh, geez, that was tough, so it's got its own name, because SCOTUS kept doubling and tripling down on their original supposition that the 14th Amendment applied due process protections to corporations and businesses, and was superior to police powers to protect health and safety, prioritizing business interest over worker protections again and again and again. Now, David A. Strauss, a professor of law at the University of Chicago, describes this period as, quote, an era in which the Supreme Court invalidated nearly 200 social welfare and regulatory measures across the country. SCOTUS really stuck to their guns here, keeping the right to contract at the forefront of their decision-making constantly. I would argue, at the reckless disregard for public health. Yeah. A well-known example of this attitude post-Lochner era is the 1923 case of Adkins v. Children's Hospital of D.C. Nice. Oh, yeah. Now we're talking. Yeah. Get that children's hospital out of there. In 1918, Congress had enacted a law guaranteeing minimum wage to women and children employed within the District of Columbia. Yeah, it's cartoonish. All right, let's just get through this together. Yeah. But the children's hospital sought an injunction against enforcing.
No, wait, what?
Yeah, they sought a court injunction against enforcing the law. SCOTUS ruled in favor of the hospital. Too bad, women and children, stating that the minimum wage law violated the right to contract embedded in the 14th Amendment, the due process clause of the Constitution. In other words, employers and employees should be able to engage in labor how they see fit without legal interference.
Ain't no way. That is crazy.
But hold on, here we go.
I'm picturing like child doctors working 18-hour shifts.
Yeah. The court also argued, pretty much.
Yeah.
The court also argued that women, the court, not the parties, also argued that women should not receive more protections than men, though they would soon overturn the specific stipulation when they upheld an Oregon law that limited women's working hours in Mueller v. Oregon in 1908.
Wow.
So the context here is that women, were not, they were basically property at the time. I don't know how else to say that tactfully.
Yeah.
Women's suffrage was not really a thing in the mainstream.
Yeah.
So that particular, I'm gonna stay hands off from that judgment because the protection for women's here. But the cartoonish thing to focus on is that women and children have no minimum wage when working overtime at the hospital.
That's crazy.
Yeah, exactly. So
I just love that it's a children's hospital.
Right.
Also.
That's just the extra layer of those children hospitals. You'd think they'd be doing the right thing, but no, they were owned by men.
Yeah, exactly.
But they were still owned by men, especially since during this era there was almost no. This is before the Great Depression and the New Deal. There was almost no welfare state. In fact, Social Security wasn't even a thing at the time. So elderly poverty, horrible domestic violence, there were no social services at all. Not that we have good ones now.
Yeah.
But at least they were government included. Now, private organizations, charities, religious institutions stepped in to address some of that void. But many of these foundations were owned by robber barons.
Yeah.
Right? Because the Vanderbilt University, the Rockefellers built a bunch of institutions and museums. At least that's what they fucking did at the time. And now they just build clock bunkers in Hawaii where they evict natives. I miss that about this era. Now, anyways, the right to contract was heralded over all else. It trumped any consideration of public health, worker protections, civil safety measures, and citizen well-being. To quote the Columbia Undergraduate Law Review, quote, while one could argue that the court did consider this in Lochner, the blind over-reliance upon the Lochner precedent throughout the following 3 decades undercuts this consideration.
Oh, my God.
It's a little bleak, basically. To recap, SCOTUS had just struck down a minimum wage law as unconstitutional, but things are about to change because 30 years, wind forward 30 years, what hits us?
I mean, the Great Depression.
Yeah, the Great Depression. And also Nazis, which I remind you, we exported. Eugenics was our big thing. Our thought leaders legitimized eugenics in a way that Germany couldn't have. They were still recovering from World War I. Yeah. All their universities were demolished, and so all these Western as in literally Western American thought leaders were talking about people's skull shapes. They legitimized that. Anyways, Nazis got into power. Little mustache man invaded Poland and a bunch of other stuff. And the Great Depression hit us, and the huge effort to mobilize the country in the wake, in the face of World War II. Yeah. And that brought about the 1937 decision striking down Lochner because labor started to swing the other direction. So this is when Franklin Delano Roosevelt came in or started to come in and was like, hey guys, shit's kind of fucked.
Yeah.
We really need a new deal here to reset everything we've done to this country.
Yeah.
And the year is now 1937, and a case has come before the Supreme Court that is destined to turn the pro-business attitudes and ruling in the other direction. And to this day, SCOTUS actually hasn't looked back substantially yet. They've trimmed and modified at the edges, but substantially the foundation of modern labor practices is centered on West Coast Hotel v. Parrish. Now, the West Coast Hotel Company v. Parrish came at an important time in American history. The Great Depression had gripped the country for the better part of a decade, and the legal and political bodies at every level of government are trying to use policy to stabilize the economy. What this meant was that the Lochner decision was basically tying the hands of a lot of municipalities to break up Hoovervilles and maybe be like, hey guys, maybe we shouldn't be putting rocks in our soup.
Exactly.
We need standards here. Shit's going crazy. I can't stop the right to contract, and right now everyone is taking a job for almost free because there's nothing.
Yeah.
Right? We got people speaking 3 languages and working as shoe shiners. It's just it was a big problem for policymakers. its language over the freedom, the Lochner decision and its ironclad favoritism of businesses presented major challenges for FDR. He even had a plan to expand and pack the court in order to get more progressive economic measures from the New Deal passed judicially, though he never ended up following through with that. And FDR and what was at the time the Democrats. I more accurately, I should say, this was a different era before the Great Switch, because at this time we call them Democrats, but they were actually conservatives. And the Republicans, quote unquote, were the liberals. So like, there's some nuance there, but basically these guys recognized that like, yo, we got to have some government intervention here. And so they were ready to like pack the court to get the justices they needed to get the votes. And luckily that was never necessary because the justices realized they dug themselves into quite a hole. So from 1933 to 1935, Elise Parrish worked as a hotel maid in Washington State.
Wow. Hey.
Her employer, the West Coast Hotel Company, had refused to pay her the minimum wage. Let's go, guys. Had refused to pay her the minimum wage required by Washington state law for female workers. Remember, women were still considered property, so like women usually had minimum wage and labor protections, but they're usually lower than men, and a bunch of social commentary there we don't have time to get into.
It's just crazy. Like, this all feels like ancient history. My grandma is 103 years old.
Oh, yeah.
So she was like in her 20s when this was happening. Well, like teens.
My grandfather is 99. Yeah, he was live for this shit. He was conscious. Anyways, required by Washington state law for female workers, so just stop paying. After she was fired from her job, she went to court to demand she be paid the difference between her paychecks and what was legally owed to her by law for the hours she worked. At the trial court level, called the Superior Court here in Washington and not the fucking Supreme Court, the court ruled that the Washington minimum wage law was unconstitutional, citing Adkins v. Children's Hospital in its infringement of freedom of contract.
Wow.
Yeah, so they weren't like, hey, remember that children's hospital that ripped off all these children and orphans?
Yeah.
Let's bring that guy back in. Yeah, that guy seems relevant. She appealed to the Washington Supreme Court. Well, appealed isn't the right word. We got up to the Washington Supreme Court where they actually sided with Parrish.
Okay.
Washington Supreme Court. West Coast Hotel was like, ain't gonna take that shit, and they asked for cert from the U.S. Supreme Court, which was granted. So now they've made it back up to the U.S. Supreme Court.
Jeez.
In a 5-4 decision, so we flipped back from Lochner. SCOTUS held that Washington Supreme Court's ruling that the state minimum wage law was applicable was constitutional. Boom. Referencing Mueller v. Oregon in their argument, the majority ruled that the state may utilize police power to restrict the freedom of contract. Basically citing back to that dissent from Lochner, where the guy was like, hey guys, like freedom of contract exists, but maybe we shouldn't. Like maybe we can go less dick wild here. Like, can we maybe have some minimum? Maybe
we can protect our citizens.
Yeah, I think we can do both these.
I don't know. I don't want to sound like some crazy lefty.
Can you imagine like that meeting, like some like the other justices in the room, and he's like, not to be a dick here, guys, but maybe we should have some health safety regulations.
Just a little.
Anyways, the majority ruled that the state may utilize police power to restrict the freedom of contract. This ruling mowed over the precedent that SCOTUS had set in Adkins v. Children's Hospital and decisively ended their business interest in the Wild West of the Lochner era. So it ended the Lochner era. This narrow 5-4 ruling was made possible by Justice Owen Joseph Roberts' defection from his usual conservative ruling bloc.
Wow.
That typically prioritized business interests. According to Oyes, Justice Hughes, who wrote the majority opinion, wrote, quote, President Franklin Roosevelt's reelection in 1936 and the impressive achievements of the New Deal caused Roberts to abandon his affiliation. In the dissenting opinion, there we go, Justice Sutherland criticized Roberts for flip-flopping and stated that the public opinion should not sway a justice's interpretation of the Constitution. Yeah.
That's interesting.
This is a situation where I actually do agree with Justice Sutherland, where I don't think this is actually my big criticism of Alito and Justice Thomas right now on the Roberts court is that, like, if you're going to be pig shit, be intellectually consistent.
Yeah,
right?
exactly.
And I think that's, I do agree with the outcome, but I think that's a fair criticism here, because he's like, hey man, we're not here to interpret public opinion. That's the political question of the legislature and executive branch. We just call balls and strikes.
Yeah.
How many people want it to be a ball or a strike or a home run? That should not weigh in our decision. That's like the whole moderating point of the court. So my nuanced opinion here is like, hey, yeah, I think Sutherland's right here.
Yeah.
I also think that, like, yeah, thank God Lochner is gone.
Yeah, I know.
Yeah,
Seriously.
thank fucking God.
Jeez.
Yeah, so
Holy.
so he was a fan of the New Deal.
Uh-huh.
So conservatives, this is where I think we should stop and say, again, these were the Democrats, but they were conservative, and the Republicans were liberal, but sorry, and then the Republicans were the liberals. There we go. Sorry, got my tongue tied there. The distinction was that this was before integration. So keep in mind the context here is when we say the New Deal, we do not mean the New Deal for black people or anyone too brown, right? And I think the mistrust of government in the Republican Party, or conservative, I'll say conservative for simplicity. Sorry, they switched. The distrust of government, massive social, financial intervention into our lives.
Yeah.
The suspicion rose markedly after the 1960s when black people could now participate. And so remember, the weird lack of objection to the New Deal may be influenced by the fact that it was only white people who were getting it. I'm not saying that in every case. Just keep that powerful context in mind when wondering, hey, what are all these conservatives doing cheering on Franklin Delano Roosevelt? That's what was up.
Yeah.
And I think and then it was marked by welfare queens, lazy layabouts, et cetera, in the 1970s onwards, and then all the white people fled the social programs, and then we've been defunding them ever since. That's sort of the TLDR since the 70s and 80s onwards to 2025.
Gotcha.
Yeah, so a lot of people don't think about that. Now, the Supreme Court took a new stance when it overturned Lochner. Lochner had created the idea of economic due process, and that business owners were protected by the 14th Amendment, and they are still protected by the 14th Amendment, but it's now subordinate to police powers firmly. We can get into employment law and all the stuff required later, but the government now routinely regulates it. If Lochner had been upheld, I actually don't know whether or not anti-discrimination clauses would even be possible in business and workplaces.
Whoa.
Because if you think about it, it's like,
yeah, it's
you can do whatever you want.
Yeah.
You can, do you want to not want to hire gay people?
You sign the contract.
Yeah, exactly. Yeah, and that's pretty much the whole basis of Lochner. It's like, hey, you have a right to sell your labor. Businesses have a right to contract with whoever they want. Laissez-faire, hands off.
Yeah.
I don't know what sort of public health laws we would have, whether or not you could trust what you ate, what you slept on with those mattresses I referenced earlier, whether or not we could trust that anything be manufactured properly, or that your airline pilots are required to only have so many flight hours to make sure they can stay awake. Truckers in the United States can only drive, I think it's like 11 hours per day at most, and I think they're capped. They have another cap per week so that they can't exceed that. And all of those ideas are to keep people safe. Regulations are written in blood. Also, a ruling upholding Lochner probably would have disregarded the equal protections rights under the 14th Amendment in favor I don't, sorry, what I'm trying to articulate here is that I'm not sure the interpretation that like contract liberty above all else is even good faith, because you inherently ignore the vulnerable positions of people who are selling their labor.
Yeah.
Right. And I think what's so important to remember is that if the law enforces a completely even playing field, then people with more money, resources, and soft power are inevitably going to get more rights. Yeah. Or effectively going to get more rights. And remember, you should only respect a court. I'm looking at you, innocent audience member, me on my soapbox. You should only respect a court if it is working to expand, uphold, or protect the rights of people who are not being served by the existing political process. And businesses have always been well treated in this country. Yeah, I think in some ways that's a good thing. We have the American corporation is the greatest wealth builder in all of history. Like, not just now, but like historically through all time, American corporations invent, produce, and share and innovate in ways that I can never imagine, but this goes too far. On the other hand, some argue that values that Lochner era embodied have not gone away. Like they've merely moved from constitutional law to find a home in labor and employment law. So there are many things wrong with labor and employment law. Like in my opinion, some things that would not legally qualify as a hostile workplace or sexual harassment are allowed to stand far too often. And when courts apply many of the workers' protections first adopted under the New Deal, they were still driven by Lochnerian principles in a behind-the-scenes sense. They were disregarding the imbalance of bargaining power between businesses and workers. Yeah, how are you feeling so far?
Yeah, no, it makes sense. You can really see the through line, and that like I don't know. There could still be people who agree with the Lochner decision who are like, well, like they like, and I feel like you hear that all the time still in like like people appealing for union busting.
Yeah.
Like,
well, I mean, Lochnerian, like employment at will.
Mhm.
And everywhere, I think Montana's the only state in the union where you're not an at-will employee by default. What at-will employee means is that, like, Sam, to use Sam as an example, talking to the camera, Sam is a W-2 employee of the Hemet Law Group, collaborates with us for this podcast. I or another firm leader, or really anyone in a position to fire someone, could fire Sam for any lawful reason. And that could mean he wears the wrong shoes to work.
Yeah.
I don't like the way he looks, like literally arbitrary, any reason, no justification required.
Which is why I wear good shoes.
Yeah, exactly. Which is why Sam is, so great to be wearing shoes with us in the studio. But what this means is lawful is like there's some protections and carve outs for like protected classes, sex, gender, age over 40 or 50, depending on your jurisdiction, religious affiliation. There's some limitations there, but generally speaking, that I can fire anyone I want at any time for any reason with no notice most of the time. Yeah. That's Lochnerian. Yeah.
That makes sense. Wow.
So let me like rally this by walking you through some cases where the imbalance of employer-employee bargaining power has further accelerated under the Roberts Court, which is our modern-day Supreme Court. Thank you to the Illinois Law Review. So Epic Systems v. Lewis, SCOTUS largely permitted employers to avoid class action claims by workers. In Walmart Stores, Inc. versus Dukes, go Walmart, SCOTUS made it more difficult for class actions to be certified, right? And remember, like class actions are how you hold large players accountable for small incremental actions that it's not worth suing over. If in practice, if I had a bunch of employees and I stole $100 from each of them, easy money. Because what are you going to do? Hire a lawyer for $5,000 to come sue me and spend 3 months? It just doesn't make sense. So class certification is how these big employers are held accountable, and the Roberts Court has been undermining class action certification. SCOTUS made it more difficult for raise the standard of proof needed for employees to prove discrimination to begin with under Gross v. FBL Financial Services, Inc. In Vance v. Ball State University, they also limited the scope of supervisor liability by changing the definition of who can be considered a supervisor.
Wow.
And Janus v. American Federation of State, County, and Municipal Employees, Council 3-1, made dues optional in public sector unions in the name of freedom of speech, is that you could not compel union members to fund the union. Problem with that, if the union isn't funded, it can't function.
Yeah.
Yeah. There's even more examples, but like that's basically the state of play. Is that like, make no mistake, just because Lochner was overturned does not mean its enduring soul does not color every part of our lives. Yeah.
Wow.
Yeah. How this is where we ended here. How you feeling?
I mean, yeah, it's just crazy to hear like the history of labor in the U.S. It's all so recent. I mean, the history of like labor rights in everywhere, all over the world is so recent, and I feel like it's you assume that it's been longer or it's been around longer.
It's been like 1.5 lifetimes.
Yeah.
Actually, really just one lifetime.
One lifetime.
Yeah, just one lifetime. It was one guy. America was founded 3.5 guys ago.
Yeah, I know. Seriously.
About 3.5 guys ago or so was America.
Yeah.
That was the 1700s.
Yeah.
So, yeah.
Well, it's like George W. Bush's grandpa or great grandpa was a Minuteman or something.
Oh yeah,
like it's like so direct.
My great grandfather was the fucking one of the vice admirals in charge of digging the fucking Panama Canal.
Whoa, that's wild.
Yeah, Admiral Davis. Fun fact: my grandmother Elizabeth Davis, he was in her family, so adjacent. The Sochas aren't involved, thankfully. But he fucking dude lost like 1/3 of his men to like various jungle fevers. So he was
hilarious.
He was a dipshit. Yeah, exactly. Yeah, I'm glad I wasn't out there. But to think that like family members that I have never met nor will ever know are involved with such great moments in history. Fucking freaks me out. Guys, let us know what you think about this week's episode. I really appreciate the time and support. We'll be back for more programming soon, but I just wanted to lay out, while we're thinking about wealth inequality and political turmoil, I felt that revisiting Lochner was something really important for all of us.
Yeah.
Thanks so much. Gossipaboutprejudice.com, link in show notes, gossipaboutprejudice@gmail.com. Don't be mean to me. and we'll see you soon.
Later.
Bye.